It became something of a media circus because, of course, there were perhaps some sections of the media quite vociferously saying that he was guilty. But you also had the strange circumstance where, of course, in Victoria, things were heavily suppressed. So Victorian newspapers and news outlets couldn't report a lot. But interstate, and particularly overseas, it was almost like it was open slather. Now, in the era of the internet, that makes absolutely no sense because you and I can go online and read the Daily Mail from the UK or any other publication for that matter, and we could read things that you weren't allowed to publish in Victoria. What is there to be learnt, I suppose, from a media law perspective about how we deal with these issues? Because it was very problematic in Pell's case.
Look, and why was that problematic? Because in Victoria there was no option but for Pell to be tried by a jury. And the number one reform that's obviously needed is to give the Victorian judiciary the option, not compel them to have a judge-alone trial, but give them the option in special cases where it's clear that there's a risk to a fair trial to have a judge-alone trial. It seems blindingly obvious. It's been happening in New South Wales for many years. And it works. There's no reason why it can't work elsewhere.
Well, I believe it happens in South Australia as well. Is the idea of the jury trial perhaps on the way out? And I don't know whether it's totally dead, but particularly in the era of social media, particularly in high-profile cases, it just doesn't fit, as you say, the bill.
Look, you're absolutely right. Social media and the internet have made it inevitable that you'll find one curious juror who will ignore their oath. They're supposed to decide cases only on what they hear in court. But we've seen a number of cases where jurors ignore that, get online and do their own research and think that's how they're going to decide cases. It's an easy way around it, and that's to do what I've suggested. Now, there'll be resistance to that. A lot of people will say, well, the jury is a fundamental right. Yes, it is a fundamental right, but that was developed before the age of social media and the internet, which has undermined the premise that you can get serfs off the field and put them in a court and they won't know anything except what they hear in argument. That doesn't work anymore.
No, it certainly doesn't, and I think the Pell case proved that, and perhaps a few others we've seen in recent times as well. Chris Merritt, thank you for joining me today.
Quite okay.